Your Lordships,
Yes.
I beg to mention item number 6.
6.
Yes, Your Lordship, I'm for the appellant.
You're for appellant.
Yes, this matter may be placed up to 2 weeks. The leading counsel is could not appear in the court due to some personal difficulty.
What is left in this matter?
Your Lordship,
You were having a government quarter.
yes, Your Lordship.
You have been given a temporary quarter. Government says we will pay for it. What is your problem? Who is the leading counsel?
Mr. D. Kamduk.
We'll have it. We'll have it on 12th.
Yes, Your Lordship.
On the request of the learned counsel, Mr. What is your name?
J. Koyu.
The matter is adjourned today. This on 12 March.
Obliged.
My Lordship, I would like to mention item number 8 was to the supplementary hearing. Lordship, I am not ready with the paper book, Lordship. May be hearing on the 21st, on the fixed date, maybe.
Paper ready. Paper ready.
Lordship, on 21st, Lordship.
You want it on 21st.
Lordship.
Lordship. I'm for the appellant, amicus.
After hearing the learned counsel from both sides, the matter is adjourned today. List on 21st March
Obliged,
Obliged.
Lordship.
for hearing.
Lordship.
May I, my lord?
Yeah.
My lord, item number 7, my lord. Here I am on behalf of Mr. Tiritara, my lord. His health is due to some health issue, my lord. He is not possible. After 2 weeks, my lord.
Health issue, we can't say anything.
After 2 weeks, my lord.
On the request of the learned counsel, Mr. What is your name?
T. Kamchi. T. Kamchi.
Comes the matter is adjourned today. When do you want it?
After 2 weeks,
List after 2 weeks for hearing.
much of this.
Item number 9.
My pleasure, lordship.
Yes, Mr.
My lord, 15/1/2024, the tender evaluation committee has, my lord, declared my tender as non-responsive. That my amount annual turnover is below, my lord, as prescribed in, my lord, clause 1.7.4. Clause 1.7.4. Now, my lord, this 1.7.4 at page 60, your lordship will find. 61, my lord. Clause 1. The bidder should have had average annual financial turnover gross of not less than 158.50 crore on any works contract during the last available 5 years. Balance sheet duly audited by chartered accountant. Two interpretation came up before this honorable court, before the honorable single judge, and the honorable single judge has taken a view with regard to the word during, saying that it is not any year, any of the year. And thereby, my lord, the interpretation that had been given by the government side, that it is a, my lord, this has to be, my lord, average of 5 years. And thereafter, my lord, apart from that, my lord, there's no other, my lord, consideration was made. Even, my lord, we could not, my lord, submit any other grounds. So, my lord, though a writ appeal was filed, realizing that, my lord, these points were not raised before the honorable single judge. So therefore, that was withdrawn, which had liberty to file afresh. And then, my lord, a review application was filed. Honorable single judge in the review application has come to a conclusion that the grounds available for review is not present in the case. However, these are the good grounds to raise the issue before the appellate court. So that's how, my lord, we are before your lordship. Now, though, my lord, I am challenging both the review order as well as the, my lord, order dated, my lord, 29/1/24 of the honorable single judge, whereby my interim order was vacated. But if your lordship, my lord, exercise the appellate jurisdiction, taking into all consideration, in that case, my lord, the review justification or, my lord, legality or validity of the review order may not be gone into, my lord. So in that sense, my lord, we'll find, my lord, coming back to the, my lord, page 61, my lord, the core issue before the court was whether the tender evaluation committee has the my lord, power and jurisdiction to reject a tender for this, my lord, turnover being less. Well, that has, my lord, that is the core issue. But here your lordship will find none of the clauses in the tender, my lord, RFP attaches with the condition that violation of or non-fulfillment of condition, the tender is liable to be rejected. Rather, Schedule D, which, my lord, prescribe the evaluation criteria, my lord, will find at page 87. It prescribes a different mode, my lord. Wherefrom it is clear that if someone fulfills, my lord, this 158, he may get maximum, perhaps, my lord, 20, as, my lord, mentioned in, my lord, serial number 1, clause 6.2. But if he gets up to 10, he fulfills that criteria. Similarly, the other clauses also, though maximum marks has been assigned, in the second two column, your lordship will find out of this 40 marks, if someone gets 40, then also the total marks has been assigned by 100. And out of 100, if someone gets 50, then he is, my lord, has to be judged as a, my lord, responsive. Similarly, with the other two, my lord, regarding plant and machinery and the staff technical also, my lord, total 20 marks have been assigned. If someone gets, my lord, 10 marks, his, my lord, he has to be declared. Overall, one has to receive, my lord, 60 marks. So that is the given in the next page as well, my lord. So therefore, these should, my lord, clearly project that the, my lord, achievement or the mentioning of the maximum amount of 158.5 crore is not mandatory. And more so, when the private respondent number 7 himself has not qualified, but he has been, my lord, declared as responsive. Similarly, 8, 9, 10, they have also, my lord, violated various clauses, my lord, with regard to power of attorney, with regard to plant and machinery, as well as, my lord, the annual turnover, single work, etc. I'll take your lordship, my lord. So they have also been, my lord, declared as responsive. So therefore, my lord, this submission is the entire technical evaluation committee, my lord, adopted a procedure which was not envisaged by the, my lord, RFP itself, my lord. If you had that particular, my lord, the procedure that if someone doesn't give 158, it should have been, my lord, clearly spelled out, my lord. That is the, my lord, nutshell my case is, my lord. And second part of the matter, my lord, which we could not argue before that, and another ground we could not take it because subsequently we have come to know. One of the condition is that during the last 5 years, one has to, my lord, completed a work minimum 20% of the tender value. So that comes
90% of that work, which is 20% of this tender work. You must complete 90% of your that eligible work, which will amount to 20% of the work now tender.
Not in.
7 does not have that.
Lots of money.
And the certificate that was given to him by the NHIDCL has been said that he cannot use it.
He cannot, my lord, the categorical finding of
But-
the
But
Ex-
Mr.
executive.
What we have found,
Lots of money.
sir, and we were just having my lord and me just going through.
Lots of money.
If you come to page 87,
Lots of money.
this criteria would come in once you fulfill Schedule C.
Yes, my lord.
Huh?
Yes,
Schedule C is nothing but 1.7.
yes.
That is the eligibility. That's the minimum to come in.
Lots of-
Right? Now, 1.7.4, this court has taken, Solon Single Judge has taken an interpretation, made an interpretation, accepted an interpretation that this is 1.58 average of 5 years.
Average of 5 years.
For the timing, we cannot interfere with that. That will hold the field for the timing.
For time being, even I am not on that.
On that.
That's-
Now, with regard to 7, 8, 9, and 10, 7, 8, 9, nothing is there before there is no finding recorded by the learned single judge in the order because that was not placed before the order.
Lots.
Now, if that be so, 7, 8, 9 are the allegations that you have leveled is correct, then maybe the bid evaluation in their case may not be proper.
That's-
But unilaterally, at this stage, we cannot accept that. Until and unless there is material brought on record by the government.
Got it. That's-
The only point argued was 1.58. They have clarified. That was the end of the matter.
That's it.
Huh?
So therefore, these points were asked before the honorable single judge, if you, in review petition.
So, Mr. Soikia,
Other
best
grounds-
what, sir, sir has said is that best what we can do is, we can have this matter next week. We will ask the government to come up with a stand with regard to 7, 8, and 9. Your plea with regard to 7, 8, and 9. Let them come up with their plea. Thereafter, we will consider as to what is to be done.
They'll also produce the records, my lord.
As they want to, they'll have to satisfy us.
Because why, this.
Because you have taken specific contentions here,
Yes.
7, 8, and 9, Form C, Form G, Form F.
Yes, yes.
You have taken, let them counter that.
Yes, yes, but that is one of the, another what I am on, my lord. Before the honorable single judge on 29/1/24, it has been said that on this ground, 4 other tenders were also rejected.
Rejected.
Now, this documents is very much before your on record, my lord. Whether any, my lord, clause, my lord, empowers them to reject, my lord, that particular.
That would be an interpretation which we will not make at the initial stage because this provision 158 comes under the criteria eligibility criteria. And if you see your case is 87, 87 is qualified by the opening lines. In addition to fulfillment of requirement laid down in C, C is the eligibility to come in.
Not
Once
the
you come in,
Lots of-
marking would be in this manner.
lots of-
One
my lord,
interpretation.
lots of- my lord, opening will be clause 6.1, opening of the, my lord, this technical bid.
No, you will have
The
to
opening
see.
committee during. the
Fine. You forget the one, you come to 2. In addition to fulfillment of requirements laid down at C. So once you fulfill C,
See,
then technical eligibility shall be determined on the basis of score below.
lots of-
So otherwise, see this tender, anybody on the road can come and submit a tender.
no, in that case, your lordship. will
If there
also-
is no minimum eligibility criteria prescribed,
Lots of-
anybody can come up and say that you have not prescribed the eligibility criteria, I have given the lowest rate, give it to me. So to obliterate that, they have done. But we will examine your plea, 7, 8, 9, that's what
lots
my
of-
lord has also decided. We will examine, we'll have it next week.
lots of- One,
And let them bring their own record. Otherwise, with that interpretation, the only point decided was 158. We cannot go beyond.
my lord, that's what, my lord, what my submission is, my lord. For a moment, even if we take that particular interpretation that has been accepted by the honorable single judge, prima facie, my lord, is there, my lord. These marks, assignment of these marks, 10 and 20 and 10, maximum is 20. There is no, my lord, upper limit. From 158, if someone gets 300, in that case, he'll get the 320 marks.
This is,
There is no minimum mark as well, my lord.
see, this is a formulation made by the author.
Author.
We
They are
will
the
not
best.
go into that.
Yes.
They know it, how to do it.
How
We'll not go into it.
Lordship,
Because you have also participated looking at this.
Lordship,
You can have no grievance.
Lordship.
Thing is, whether eligibility first seen, then you come in. That's what is to be looked into. We'll ask them, let them come next week, we'll see. And you have said the process is only on.
On, my lord. So,
It
no-
has it has not culminated. If it culminates, we are here,
Lordship,
we will do it.
Lordship.
Yes, Mr. Ravi.
Lordship, this issue, Lordship.
Forget 158.
Lordship, I'm
He has brought on specific amendments
close.
that 20% criteria he has not met.
No.
And the document that he had shown, the issuer of that document has already said this cannot be used because there is some forgery involved.
Close.
So 8 and 9 also he has brought certain allegations. You get your instructions on that so that on the next day we can adjudicate whether an interim direction is called for. We are not going into the merits of the matter.
No.
Only for the purpose of an interim direction.
So, Lordship, what I'm here, Lordship, we are examining only the correctness of that interim order. The
See,
issue
the correctness of the interim order would have been there
No.
only on that point, provided the review was not there. Now, at least that review being filed,
Close.
it was brought on record before the Honorable Single Judge
No.
that these are the other points we had.
Lordship.
Now, an amalgamated appeal is before us.
Now, Lordship, the review court, Lordship, the Honorable Review Court, what they said, Lordship. This issue is still open for the petitioner to be placed before the learned single bench, which is still pending on merit, Lordship. Because,
It has been
and
said-
all these things can be, Lordship, raised before the learned single bench on the merit, Lordship, which is still pending. This issue can be decided on that, Lordship.
It has been said, any action taken that will be subject to outcome of the
Fine.
decision. That is the final decision. my lord.
But we want to satisfy ourselves with regard to those three queries because this is a public work. If a person otherwise not eligible is being now made eligible,
No.
you cannot. You cannot go beyond your terms.
That part loss adds. What I'm submitting, if the read petition itself loss, on merit loss, if that can be.
That we will pass that orders on the next day.
Loss, then I'll come with this.
On the next day, we are not going to hear this matter finally. Only thing, whether an interim direction is called for. or not.
Loss,
Only to that extent.
Loss.
And we are not passing any order today.
loss.
Huh.
I'm appearing on behalf of private respondent.
Respondent number
7.
7.
Yes.
What do you have to say on that, please?
The letter to proceed with the work has been already given us. And the substantial portion of work has been already executed by us.
Substantial portion means?
Of tender work has been already executed. We
You mean you have
completed-
done the maximum of the construction works?
Not maximum, but 7 kilometer has been already. completed.
Within this,
For my-
this is 6th.
Yes.
Today we are.
With regards to the
Within 1 month you have done.
art cutting.
Total work is for 3 years.
And within, what work are you doing? Hmm? If you have done substance, this is something very, now we'll have to stay to examine.
Art cutting has been already.
Cutting has been.
Most of it. Because like monsoon is.
You started off saying that substantial part of the work is complete.
Lordship, only the meaning is that Lordship, the work education has already started, Lordship.
Now, tell me one thing.
Anyway,
With regard to respond number 7, that certificate of yours is questioned. What do you have to say on that? That you have any other document to show that you have fulfilled 20% of the work? Only that NHIDCL certificate?
Lordship, regarding that, will file reply.
Not reply. I want an answer.
We have not received the copy on the instruction of the respondent number 7 I'm referring to.
Heard the learned
Can it
counsel
be
for
on
the
another
parties. List this matter again on. 13/3/2024. Full stop. Mr. S. Tapin, learned senior government advocate, Arunachal, shall on the next day receive instructions with regard to the claims made by the petitioner in the writ appeal as well as in the writ proceedings pertaining to the qualification of the respondent number 7, 8, Mr. Soikia, 7, 8, and 9.
7, 8, 9, 10.
9 and 10, full stop. It is full stop. The said instructions would be supported by documentary evidences, supported by documents which would be produced before this court on the next date fixed. Full stop. Mr. A. Taba, learned T. Taba, learned counsel has entered appearance on behalf of the respondent number 7, and he has submitted that the authorities have issued a notice to proceed with the work on 6/2/2024. Have you executed the agreement?
Yes.
When?
But in the online, I have annexed the document at last page.
The record is not. Panel.
And has submitted that substantial portion of the work has already been done pertaining to the earth cutting works. Full stop. Mr. Tapin shall also receive instructions with regard to the said submission made by the learned counsel for the respondent number 7. Full stop. The notice to proceed with the work, it would be subject to further orders that would be passed in the matter on 13/3/2024.
Can it be on minute 11th? 11th.
Let it be 12th if you're not possible. 12, 3, 12, 3. Mr. Tapin, you don't get that instruction.
No,
It is there.
Records of the
we
technical
have-
evaluation committee. Yes.
You find out the thing from the, you'll get the claims made by him in the writ appeal itself. 7, Form C. 8, 9, 10, Form C, Form G, Form H. Just have a look at it.
1, 2, and 3.
Yes, Mr. Kadok.
My lord. On the last occasion, my lord, I'm directed to my lord the parties the order copy.
Yes.
Passed by the Honorable Supreme Court in the same similar matter, my lord. My lord, in that my lord, similar matter, the contentions of the my lord, the petitioner in that case, my lord, where the SLP was prepared by the Union of India, my lord. That is, my lord, something different. It talks about, my lord, the section 39. 39 is,
Year 16(4) is under challenge.
my lord. And the section 16, subsection 4 is, my lord, separate proceedings where the input tax return has to
Is
be
done.
claimed.
So this has got nothing to do
Nothing,
with
my
the
lord,
Supreme
exactly,
Court
my lord.
matter.
However, my lord, in the similar case, my lord, exactly the similar case by the Honorable the Patna High Court as well as the Andhra Pradesh High Court has, my lord,
But
addressed.
nobody is appearing. Nobody has appeared
No,
for the
nobody has.
petitioner. Okay, to appear from.
Matlab, these benefits will be extended as in when matlab, they exercise the filing of the returns within time. Matlab. Then section 16(4) will be available to them. Matlab. But in such case, matlab, when section 16 is not available, matlab,
What happened? They have lost interest.
matlab, I think the counsel for the petitioner is Guwahati based lawyer.
Next week. None appears for the petitioner on call. Mr. M. Kato, Lalit, DYSGI, appears on behalf of the respondents. For the ends of justice, list this matter again on 13/3/2024.
Matlab, may I phrase it on 12, matlab.
12/3/2024. Full stop. In the event there is no, in the event further, in the event no one, in the event there is no representation on behalf of the petitioner on the next day, appropriate orders as may be called for, it will be passed by this court.
Malad, may I place the similar judgment rendered by the
Next.
much obliged.
May I play with that? This matter relates to implement functioning of Anganwadi centers, madam, especially in the location code Toa, Talo, Hook, and
The affidavits
Aptal.
have been complete here.
Yes, they have filed affidavits. Yes.
We'll have it for admissions, we'll consider.
अंगनवाड़ी सेंटर itu lagi nih ya mission hearing
Heard the learned counsel for the petitioner. It is stated in the part that the pleadings in the matters have been completed. Parties have all been represented accordingly. Registry is directed to list this matter for admission hearing after 2 weeks on a date to be so fixed by each mallet. Okay.
I'd like to mention item number
One,
on behalf of T Tapak.
all we have a permit.
T Tapak,
Oh, T Tapak, yes.
due to the difficulties,
Have you taken consent?
yeah, consent.
What is your name?
DCO.
The learned counsel, Mr. D. Sibu. Appearing on behalf of the learned counsel, Mr. T. Tapak, raised for an adjournment and also submits that he has already informed the other side. The matter stands adjourned accordingly. When do you want it?
Next week,
List next week.
Which matter?
item 1.
Yes.
Made pleasure, Lord, sir. I would like to mention item numbers 23 to 25, my lord.
23, 25.
23, 24, and 25, connected matters, my lord.
Oh, 23,
Can this be
25,
listed tomorrow, my lord? I have some difficulties.
Tomorrow. Tomorrow dispense will not sit. Tomorrow and day after tomorrow. You have to take it next week.
Next week.
Hmm.
Next week, I have some, then in that case, my lord, can it be on 18th, my lord?
18, okay, all right. On the request of the learned counsel, Mr. D. Panging, the matter is adjourned today. List on 18,
18, my lord.
18 March.
Yes. And item number 26 also, my lord. The appellant has, my lord, in the meantime passed away. So,
Okay.
when 2 weeks time may be granted, I will file appropriate application.
The learned counsel, Mr. D. Panging, appearing for the appellant submits that the appellant has expired
Yes.
and therefore he
26.
needs some time to take appropriate, he needs some time to file appropriate application to the prayer is allowed. List after 2
2
weeks.
weeks. Obliged.
My lord, I'm
Yes.
here on behalf of Titi Tara. My
Hmm.
lord, I beg to mention item number 21,
21.
seeking adjournment for a week. Matter may be fixed on 19th.
19.
Yes, sir.
On the request of the,
Not well.
okay. On the request of the learned counsels, counsel for the appellant, the matter is adjourned today. I have also heard Mr. D.K. Panging appearing for the respondent. List on
19th.
19.
Next week, I will.
Okay, 19 March for hearing.
Much.
Yes.
Please, your lordship. Lordship, yeah, yesterday I was supposed to file one AB, lordship, but the FIR I could not obtain. So I am filing today, lordship. So this matter may be taken up today.
What is that matter?
AB, lordship, anticipatory bail
AB,
application,
you
lordship.
filed it yesterday.
Supposed to be filed, but I have filed today in the morning, lordship.
When do you want it?
So I'm taking your lordship, this matter may be taken up today, lordship.
Today?
Lordship.
All right.
Deeply obliged.
Wait, please, Lord. My lord, another matter, my lord, item number 15.
Hmm.
I am entering appearance today, my lord, on behalf of the respondent number 2. I will file my wakalatnama today.
Okay.
My another friend comes from outside. Can
Okay.
it be taken up on some other day, my lord, on 27th of March? 27th.
Item number 15. Item number 15.
15, madam. I will file my
You are
wakalatama.
for private respondent.
Yes.
26th.
Huh? The learned counsel, Mr. D. Panging, appearing for the private respondent submits that he has entered his appearance today for the first time. Therefore, he needs some time.
For 15.
I have also heard the learned counsel, Mr. G. Boru, appearing for the petitioner. The matter is adjourned accordingly. List on 26.
26.
I for state lordship.
26. I would like to hard MS H. Lakshmi, the learned additional for a state respondent. 26 March. List on 26 March.
Obliged.
Your Lordship, may I mention item number 9? On behalf of the main council, Sir Manjit Kumar Das.
Huh?
May I mention item number 9? On behalf
Item number
of,
9.
yes, Your Lordship. On behalf of main council, Sir Manjit Kumar Das. Your Lordship, the main council is unable to attend today on account of the sudden demise of his uncle earlier this morning.
Okay, you are
And-
for Chania Bangsi.
Yes, Lordship.
What is your name?
Chania Bangsia.
Your name?
Chania Bangsia.
Chania Bangsin.
Yes, Your Lordship.
Who is not coming today?
The main council?
Who is Madan Mili?
No, Your Lordship. He is from Guwahati.
Worship.
Manjit Kumar Das.
Okay.
Uh,
The
he-
Learned Counsel MSC Bangsia, appearing for the petitioner, submits to the Learned Conducting Counsel who comes from Guwahati, is not available today. And on that ground, an adjournment has been prayed for. When do you want it?
Till the next sitting of this bench.
Huh?
Till the next sitting of this bench.
No, when do you want it? After 2 weeks?
Yes, Your Lordship, till the next sitting of this bench.
Huh?
Till the next sitting of this bench.
Till next sitting of this bench?
Yes, Your Lordship.
The prayer is allowed. List this matter. Whenever this single bench sits. Again.
May I, Honor? And I'd like to mention a pending matter, criminal petition 126 of 2023, to be listed on Monday, that is on 11th. Obliged.
Item number 27. Yes.
May I please, Lordship? Lordship, this bail application has been filed for the release of the arrested accused person, who is a lady and a mother of 15 years minor school son.
What is the offense?
Offense, Lordship 302, 120B, 506, and 34 IPC, Lordship. Lordship, FIR was lodged on 5/12/2023.
Scan copy of the case diary will be required. Yes, record.
Lordship, here, Lordship, charge sheet has already been filed. Committal proceeding has also committed.
Yes.
So, Lordship, further detention of the accused person will be not required to my
Let
understanding.
the LCR come.
Yes, Lordship. Can
Heard
I,
Mr. K. Lolen, appearing for the petitioner. Heard Mr. J. Naveen, the learned public prosecutor for the state of Arunachal Pradesh. Call for a scan copy of the LCR.
Yes, ma'am.
When it will come?
Can it be on Friday, Lordship?
This Friday.
Yes, Lordship.
This Friday, what will be the date? Friday, this bench will, huh? This Friday? Oh, Friday is a holiday.
Holiday.
On Monday.
Then
Monday
Monday.
on 11. List on 11.
Obliged.
Deeply obliged, Lords.
Item number 28.
Yes.
Lordship, Lordship, this is a bail under section 439, Lordship. In connection with Internal Police Station case number 3 of 24. Registered under section 363, 366A, 376DA, read with section 6 of POCSO. Now, although, Lordship, there is a section of gang rape and POCSO.
Impugned order.
Impugned order. Yes, it was passed in the year
The order which
Yes,
you are
yes, yes,
challenging
yes, yes.
here,
2021.
page number?
Page number
Is the-
45.
45.
Yes, 45 to 49. Other under section 145 CRPC.
Hmm. Where is the book? Give me this book. Arunachal Pradesh Land Settlement and Record Act 2000. Land Settlement and Records. Huh? AP.
AP Land Settlement and Record Act. Yes, I have.
Volume 7.
Volume 7.
Yes, yes, please.
Yes, sir. Be it please, Your Lordship. Lordship, I have a allotted land measuring 600 square meter at each sector. This private respondent 4, who is now represented by my landed friend, Mr. Sonar.
He says that.
Yes, yes,
Yes.
he filed a FIR against me as encroacher, and thereby he claimed my land to be his land. And finding the matter to be involving the land issue, the Itanagar police has correctly forwarded it to Executive Magistrate, Capital Complex, for trial under Section 145 CRPC, my lord. Landed Executive Magistrate pass order in favor of me, basing on my allotment order, because possession and as well as ownership were mine. Then agreed by the order of the Executive Magistrate, respondent number 4, who is now being represented by my landed friend, Mr. Sonar, file a complaint to the Deputy Commissioner Itanagar for cancellation of allotment order. The landed Deputy Commissioner Itanagar once again dismissed that complaint letter for cancellation of my allotment order, because allotment was authentically verified and allotted to me. And agreed by that dismissal order of his complaint, this complainant once again made an appeal to the Commissioner Land Management, Government of Arunachal Pradesh. Now my question is that appeal maintainable or not? That also without making me any party. It was not maintainable, Your Lordship, because the appeal section of Arunachal Pradesh Land Settlement Act itself is loud and clear that no appeal lies unless the previous order, original order is made under this act. The previous order was not made under this act. So, again, that though the appeal proposed to be under section under the law of Land Settlement Record Act, it was addressed to my lord Commissioner Land Management, but cognizance was taken by Director of Land Management. So it also is not provided in the law. The appeal against the order of the Deputy Commissioner shall be taken cognizance by Commissioner who is in government level. Neither the Deputy Commissioner who had taken cognizance of appeal against his own order, no, the Director of Land Settlement or Director of Land Management, both of them are not government, my lord. And that Director of Land Management, very absurdly, my lord, made an order. I have enclosed it in page my lord, page 44. Page 44 of my petition. Yes.
Yes.
To the Deputy Commissioner, Itanagar Capital Complex, Itanagar appeal under section 83 1B of the Arunachal Pradesh Land Settlement and Record Act 2000, read with Rule 4446, Schedule 3 of the Arunachal Pradesh Land Settlement Record Act 2012 against order passed by Deputy Commissioner. But this order against order passed by the Deputy Commissioner, no order was passed under the law of Arunachal Pradesh Land Settlement Act. So they have whimsically and arbitrarily making such sentence and such subject in the letter. And also, my lord, this poor director of land management, Relish Genie, joint director, he is directing deputy commissioner to take cognizance of the appeal matter in his office. It is grossly illegal, my lord. On number 2 point, because deputy commissioner is not an appellate authority. Number 2, my lord, he cannot sit as appellate authority for a land allotment issued by he himself and for the dismissal order against the complaint of the respondent number 4 passed by he himself. And third point, the deputy commissioner is none of the appellate jurisdiction, Your Honor. These are my submission. And now, my issues, Your Honor, in my matter is very precise and very simple. Can a deputy commissioner override the judgment of an executive magistrate passed under section 3 or 145 CRPC or not? As he did in my case, my lord. Can a deputy commissioner decide title of land under litigation? Deputy commissioner has decided my land allotted by he himself. In his order, my lordship, I have enclosed. He decided my land, how? Out of 600 square meter, 400 square meter shall be belong to me, and remaining 200 square meter shall be written back by government of Arunachal Pradesh. So after being allotted by him, and this will be my second question, can deputy commissioner decide a title of any land under litigation? Number 3, my lord, is director of land management or a deputy commissioner an appellate authority under section 83 Arunachal Pradesh Land Settlement Record Act 2000 or not? It has happened in my case. And lastly, my lord, can a case which was initiated under 145 CRPC can be later on decided by a revenue court or a revenue officer like deputy commissioner, as it had happened in my case? With all this question, I made an appeal in the Honorable Court, Session Court UPA. What Session Court, Session Court UPA had passed order is, though the order of the deputy commissioner as an appellate authority was made under section 145 CRPC, very clearly written in the order. Though order was made under 145 CRPC, learned session judge UPA was pleased to draw a presumption that it was made under law of Arunachal Pradesh Land Settlement Act under section 83. Whereas previous.
Where is the order of the session judge?
Order of the session judge, oh, yes, my lord. It is page 86 to 89. Page 86 to 91, my lord.
Yes, yes.
Yes, now the issue to be decided between me and my learned friend, Mr. Sonar, who is representing for respondent number 4. In previous court also, His Lordship order for the appeal or notice of summoning the parties by the deputy commissioner prior to making of the impugn order. So we have submitted before your lordship that order. That order also is revealed that though the deputy commissioner was directed to take the case into appeal in his court under section 83 of Land Settlement Act, but he had not taken the case under section 83 of Land Settlement Act. In his order, in the impugn order, in the heading itself, it is clearly in bold letter written, order under section 145 CRPC. And in his affidavit filed by the additional senior government, Ms. Gotre Ete, by affidavit in paragraph 5, in the affidavit of deputy commissioner, my lord.
Who is the appellate authority under this act?
Appellate authority under this act is government.
Government.
In the capacity of secretary or commissioner, as case may be.
Where it is written?
It is
In what section?
section 83. 83.
83 is appeals.
Yes, appeal. And if we read further, yes. If such order is passed by officer subordinated to the deputy commissioner, appeal to the deputy commissioner. Then if such order is passed by the deputy commissioner to the government represented by concerned secretary.
Secretary.
Yeah, or in equivalent rank by commissioner. By the appeal made by respondent 4, who is being represented by my learned friend, was taken cognizance by Director of Land Management.
It should have been filed before the secretary.
Yes, secretary. Of course, it was very clearly submitting. I must be very clear. Of course, it was addressed to commissioner, but cognizance was taken by assistant director for director of land management. And in his order also, appellate authorities directed the deputy commissioner to take cognizance of the appeal matter in his court, who also is not an appellate authority. And also, my lord, my case here in this case is section 83, this appeal section is not applied here, is not applicable here, because no original order was made under the law of Land Settlement and Record Act 2000.
Oh, sir. The deputy commissioner's order was not under land settlement rules.
Not, yes, yes. None of his original order was made under land settlement rules. This is my lord.
May I proceed?
Yes.
My lord, first, my lord, it needs to be considered, my lord, that this is the, my lord, application under 482. This is not a writ petition. This is a 482 application, my lord, whereby the petitioner is invoking inherent jurisdiction of this honorable court, my lord. My lord, the issue before this honorable court is that, my lord, that whether the impugn order passed by the session judge, learned session judge, in exercise of its revisional power
under section 397 of the CRPC is bad, illegally sustainable, wrong or not. And the issue is that whether in exercise of power under section 482 of the CRPC, whether we can set aside or that is the limited issue here.
Yes.
My lord knows very well, my lord, 482, because earlier law was that a 482 is not maintainable against the revisional order. The earlier law was. Subsequently, that has been overruled. Now the present law is concerned. I'm not disputing, say that is not maintainable, not the question, my lord. It is maintainable even against the order passed under the revisional jurisdiction. There is no dispute so far. But, my lord, there is a caveat, my lord. The law says, my lord, not in every case whenever 482 is involved, that can be exercised against the 397 order, my lord, passed under revision. The law says, my lord, in the rarest case, when there is the abuse of the process of court, my lord, to secure the ends of justice, my lord knows very well, my lord, what are the, my lord, parameters under 482 has to be exercised, my lord. And my lord knows, the law says, my lord, when there is an alternative remedy, 482 cannot be invoked. Because when the person is left with no remedy, in the interest of justice, when there is abuse of the process, then 482 is maintainable. Now, having said, my lord, about the principle of law, my lord, which is applicable in my case, my lord, I will demonstrate why it is not applicable, this particular 482 petition is, my lord. Before coming to law, my lord, the relevant facts in brief, my lord, I will put in like this, my lord, just which is not disputed fact, my lord. Fact is like that, my lord, that of course she is my sister-in-law, the petitioner otherwise. Originally, the land belonged to our father. Then father died. Out of 600 land, that 200 square meter of land, it was for me. 400 by my elder brother. The petitioner is the wife of my elder brother, my real elder brother. So what happened is, my lord,
in the family.
In the family. Then what happened, my lord? My sister-in-law, the petitioner, what she did is like, she obtained the land allotment of all 600 square meter of land, surreptitiously.
In her name.
In her name. Surreptitiously. So initially, because that land was under my possession, so when she was undertaking possession, I lost the complaint. Then, my lord, initially 145 proceeding was drawn. This is very important, my lord. 145 proceeding was drawn. That order was against me. 145 has been declared in her favor. I am not disputing, madam. It is still that order is in her favor. Because I have not challenged that order. That is still in existence, that she is in the possession of. Now, during that time only, I came to know that she had obtained land allotment of 600 meter of land, of my land including. Then, my lord, unless I don't get that allotment cancelled, because even if I file civil suit, definitely I won't be able to win the case, because title we derive from the land allotment. This is a government land. Then, my lord, only the remedy left with me, instead of challenging the 145 order, which is still in her favor, what I did is, my lord, I exercised the right given under this Land Settlement and Record Act 2000. Because it is under this act only the land allotment is issued. Now, my lord, we have to understand his once, because CRPC procedure I have abandoned. Because otherwise, against 145, my lord, I know I cannot go against the same officer as a appeal. Against 145, there is no appellate provision. Only I can file the revision. I have no challenge. I said that I will invoke another jurisdiction under the Land Settlement and Record Act, which says that the competent authority to cancel the land allotment, if it is found that this has been wrongly issued, is the Deputy Commissioner. Then I filed application saying to the Deputy Commissioner, you kindly revoke the land allotment. My lord has to consider this one. I am not raising the issue of possession. I cannot. Already decided. I said, she has obtained illegally the land allotment of 600 area. Then the Deputy Commissioner could not understood these two separate provisions. Power under 145 under CRPC, power under section 12 of the land record. He mixed up both the things. He thought once 145 has been declared, so I cannot entertain power under the different act. So she passed an order, the Deputy Commissioner passes an order against me. No, 145 already declared. I will not enter. And against that impugn order, I preferred an appeal before the Commissioner Land. This is the provision appellate authority. Then Commissioner Land marked the matter to the Director Land, saying, and from their order has been issued to the Deputy Commissioner. No, without hearing why you have dismissed the application. Because you being a Deputy Commissioner, you have to hear under the Land Record and Settlement Act, not under the 145 proceeding. Then matter was heard. In the notice also, a specific statement has been made to them that this is a proceeding under Land Record and Settlement Act because my application was again under the Land Record and Settlement Act. He participated in the proceedings. Then the Deputy Commissioner came to the conclusion that this 600 land has been surreptitiously obtained. Only the petitioner is entitled for only 400 square meter of land. She has obtained 200 square meter of land in excess and surreptitiously by flouting certain norms or all those things. This is the categorical observation by the Deputy Commissioner. But what is wrong happened is that Deputy Commissioner in his order, my lord, and the top it said 145. The problem starts from there, man. This is exactly the issue, man. So otherwise, my lord, how the 145 already in his favor? Question of second 145 doesn't arise, water. And my lord knows under 145 how a Deputy Commissioner can go into the question of legality and validity of the land allotment order. Question doesn't come, my lord. Only 145 will restrict only the question of possession, which has already been done in his favor. Now, Deputy Commissioner, my lord, maybe lack of knowledge, whatever. Now, Deputy Commissioner passes the order, this land allotment is in excess. She is entitled for only 400. But in the order, it's written 145 in the section.
Yes.
Yes, my lord. I will come to annexures, my lord. Then, my lord, this order has been put to challenge by way of revision. 397 before the session judge. Then the session judge, after going the entire matter and after hearing the parties, session judge is of the opinion, no. Though 145 has been mentioned, wrongly quoted that section, but in substance, the power has been exercised under a different act. And my lord has seen under the act, there is an appeal provision. Now the session court has said that, no, this power is not exercised under the CRPC, but under the different act. Therefore, revision cannot be maintainable against the order passed under the Land Record Act because this is not the order passed under CRPC 145. That's why the criminal revision petition has been dismissed. Against that order, my lord, the present criminal petition has been filed. Now the question is, my learned friend has to show what is the illegality and perversity. My lord knows that while exercising 482, we are not sitting on the merit. He has to demonstrate, my lord, what is that illegality and perversity committed by this session judgment. Is not it the, my lord, the decision rendered by this session judge is the most plausible and correct, my lord, considering the materials on record? When the order says that land allotment has been cancelled, and there is a provision under the act itself which provides that if you are aggrieved, you go file an appeal before the commissioner, or you have an option to challenge by way of writ petition. Also, still he has an option, not disputing. But the question is that how you will challenge the order passed under the statutory act, which is not passed under the CRPC, by way of criminal revision and by way of criminal petition. Now, the my lord has to only determine that only quoting of section 145 will itself completely change all the substance that is there in the order, my lord. Because order which my lord reads, leaving aside that quoting of 145, what it will show, my lord, this entire discussion has been done in respect of how the allotment has been procured.
Yes.
Now, my lord, I will come to this having said, my lord, this is basically the facts of the case. I'll come, my lord, this annexures, my lord. My lord, may I take to, my lord, page number 30, my lord. I will start from page number 30 of his petition, my lord. 31st October 2019, my lord.
Yes.
My lord. My lord, this is the order, my lord, 30 and 31. This is the order passed under 145. It is still valid. It is in her favor. Because nobody has put a challenge. Now, thereafter what happened, my lord, then my representation on the basis of why this order has been passed, my lord, kindly turn to page number 32, my lord. Now, my friend is trying to project, my lord, saying that my application, my lord has got page number 32.
Yes.
My lord. My lord, kindly see the, my lord, subject itself. What I am saying, my lord. Revocation of land allotment number so and so in favor of Landita. Now, my friend is saying, my lord, this is an appeal against the 145 order. Not at all, my lord. My lord, what I am saying here, because my lord, I am very fully aware, because land allotment cannot be cancelled under the CRPC, my lord. How it can be cancelled under the 145? But I am not disputing so far the possession order. It is still with her, my lord. Then I said revocation of land allotment. This is under the different act, my lord.
Different.
My lord. Then, my lord, this order, my lord, please, next, my lord, page number 43, my lord. My lord, page number 43.
Yes.
But the deputy commissioner, my lord, what he misunderstood, that since 145 already, order is already in favor of the petitioner, so he cannot entertain my application. He rejected without hearing me. Then, my lord, against this order, kindly turn to next page, my lord. Page number 44. This is, my lord, pursuant to my application, my appeal, my lord. The matter was again remanded back to the deputy. My lord, subject, my lord. What is here? It is saying, my lord, appeal under section 83(1)(b) of the Arunachal Pradesh Land Settlement and Record Act, so and so and so and so. My lord, this, because my appeal is under section 83(1)(b) of the Land Record. Therefore, my lord, the matter was remanded back to the deputy commissioner, saying you had the matter under the Land Record and Settlement Act. Thereafter, my lord, this 22/10/2021, this is the order, my lord, page number 45, my lord. My lord, on the top of it, but it is written an order under section 145 CRPC. Now the problem starts from here only. Now my learned friend's contention is that since it is written 145, so it has to be considered as 145. So therefore, two 145 proceeding cannot be held. This is his contention. What our contention is that this was the same condition put before the learned session judge. Our contention is that quoting of section will not change the substance of the order. We have to understand on what basis petition has been initiated. It is something, my lord, if I file a petition under section 482 of the CRPC, because well, the nature of the petition will on the basis of the application made, my lord. Now, my lord, if a, my lord, court, my lord, passes application under 482, saying, my lord, wrongly, then no, I am passing under section 226, writ petition, my lord. That cannot change the, my lord, nature of the application, because it has to be 482 application. Maybe his understanding may be 226, but I have to challenge that under 482 only. This is what happened exactly in this case. He has quoted 145 wrongly. But my lord, if I read entire this statement, my lord, what is the finding of this case, my lord? Now, the finding of the judge order of this 22/10/2021, my lord, it cannot be the order under 145 for two reasons. First, my lord, validity and legality of the land allotment order cannot be looked into under one section 145 of this CRPC. Not permissible under. That is the specific issue raised by me. I never raised the issue of under whose possession land is. Still today, I am not disputing. So far, by the strength of the earlier order, she is in the possession.
You are challenging the allotment order.
Allotment, basically allotment. Then the deputy commissioner said, yes, we found it on the record that you have wrongly obtained the excess of 200 Therefore, cancel, attach the excess land and kept with the government. This is a government land. So this is not something the deputy commissioner has given me, my lord. No, because until and unless I also don't obtain the allotment, how can I take it? So this is a government land, undisputed fact. Then, my lord, this order was put into challenge in the revision petition. Then, my lord, the impugned order that has been passed, my lord has seen page number 86 onwards it starts, my lord. I'll just read out the, my lord, this operative portion, relevant portion, page number 90, my lord. It starts from page number 90 onwards.
Yes.
My lord. Para 3, my lord. These are the reasoning given by the learned session judge, my lord.
Para 13.
Para 13, my lord, onward, my lord. As observed above, having agreed by the decision passed by the President OP had preferred an appeal before the Commissioner of Land Management under Section 83 of this so and so. The Commissioner Management had remanded the case back to DC for holding a fresh hearing, consequent upon which the impugned order was put. After hearing both the disputing parties, the learned DC had exercised the jurisdiction under Section 12 and 79 of the Arunachal Pradesh Land. Thus, the DC acted as the collector of his remedial jurisdiction and not as the magistrate under the court. Annexure so and so is the copy of the impugned order and its heading is order section under Section 145 CRPC. The dispute facing the parties and the accepted fact is that impugned order has been passed in compliance to order of the Commissioner Land Management Government of Arunachal Pradesh. Thus, the proceedings having held in accordance with the Arunachal Pradesh Land Settlement and Records Act 2000 read with Rule 45 and 46 of the so and so, mere reflection of Section 145 in the impugned order will not change the statutory provision under which the learned had exercised so and so. There apparently does not have remedy under Section so and so and so and so. Now, my lord, this reasoning, my lord, it is on the as per the, my lord, on the basis of the materials on record, my lord.
Yes.
There is nothing, my lord, we can find out, my lord, that any, my lord, illegality or perversity in the order, my lord. Where is the abuse of the process of the court by the learned session judge, my lord? Learned session judge has exercised its power, my lord, statutory power, my lord, on the basis of the material on record after hearing the parties. The specific finding, my lord, that the proceeding was initiated pursuant to the matter remanded back by the commissioner to the deputy commissioner, and that too under the land settlement record. My lord, having said that, my lord, unless my friend shows otherwise, my lord, what is the perversity and illegality in this order? And my lord knows 482, my lord. Otherwise, this is a sort of second revision. Now we are sitting against the revision order passed under the revisional jurisdiction passed by the learned session judge. So standard is very high. Only showing that another possible view is possible will not entitle the intervention, my lord. Now only has to say that exercising there has resulted in miscarriage of justice, gross abuse of power, my lord. Now, my lord, having said, my lord, that, now, my lord, certain few maintainability, I will raise the issue, my lord. Now, once we held, my lord, that this order has been issued under the Land Record and Settlement Act, my lord. Now, my lord, Section 83, my lord, of the Land Record and Settlement Act, what it says, my lord. Is it, my lord, he is remediless, my lord? No.
Yes.
He has so many remedy, my lord. My lord, I will just read appeal section for 83, my lord. Save as otherwise expressly provided, an appeal shall lie from every original order passed under this act. If such an order is passed by an officer subordinated to the deputy commissioner, then, my lord, second, if such an order is passed by the deputy commissioner to the government represented by the concerned secretary, my lord, this is available to him, my lord. Till today, it is available with him, my lord. And he knew, my lord, that the proceeding was for cancellation of his land allotment. Now, only because you cannot take advantage, only because wrongly or rightly a misunderstanding 145 has been quoted. Now, you can go there, or other alternative he has, my lord, by way of filing the writ petition. It says that the DC has wrongly issued the power, but not under, my lord, invoking the 482 under the criminal petition, because cancellation of land allotment is not the criminal proceeding. It is a proceeding initiated under the separate statutory act, Land Record Act. Now, my lord, this appeal is there, my lord. Even revision is permissible, section 85. Even review is permissible under section 86. 3 alternative remedy is with him. Appeal, revision, review. Apart from there, writ petition also. Altogether 4 remedy he has. Now the law says, my lord, 482 will be maintainable only. First, my lord, when the order passed under the revisional jurisdiction is to put challenge, it is in the rarest of rare case. Otherwise, when there is an alternative remedy, 482 is not maintainable. My lord, may I just read one paragraph of the judgment, my lord? This is, my lord, 1977 for SCC, Madhu Limaya case, my lord. All those issues have been discussed, my lord, when 3897 order to pass revision order, then when 482 can be invoked, my lord. I'll just read. Para, my lord. A8, my lord. The para 8, page number 555, my lord. Just read this.
555.
Yes, my lord. 555.
Yes. Para?
Top, my lord. It is para, last portion of the para. At the outset, the following principles may be noticed in relation to the exercise of the inherent power of the court, which have been followed ordinarily and generally almost invariably, bearing few exceptions. That power is not to be resorted to if there is a specific provision in the court for the redress of the grievances of the aggrieved party. It should be exercised very sparingly to prevent abuse of the process of any court or otherwise to secure the ends of justice. It should not be exercised as against the express bar of law engrafted in any first part, my lord. This power is not to be resorted if there is a specific provision in the court for the redress of the grievances of the aggrieved party. My lord, I have already shown.
Yes.
My lord, I have already mentioned, my lord, referred that section 83 appeal, revision, review, all are there under the act. When there is a provision, even other alternative is also there. How you can resort filing 482, my lord? Not permissible. Because, my lord, once, my lord, learned session judge has held, this is a proceeding under the Land Records Act. Unless my lord comes to a very different conclusion saying, no, learned session judge without material has come to the conclusion, then matter would have been different. But once, my lord, that foundation is there, that it is a proceeding under the Land Record and Settlement Act. Then, my lord, the remedy is not 480. The remedy is you have to invoke the provision of the act or the writ petition, my lord. For that purpose, my lord, this one. Now, my lord, under the two satisfied, only, my lord, whether the quoting of wrong section will affect the substance of the order or not. 2004 12 SCC. Para 9, my lord.
Para 9.
Yes, ma'am.
Yes.
My lord, it is well settled that if an authority has a power under the law, merely because while exercising that power, the source of power is not specifically referred to, or a reference is made to a wrong provision of law, that by itself does not vitiate the exercise of power, so long as the power does exist and can be traced to a source available in law. But here is the case. Only because saying 145, wrong quoting, will not change the nature of the order, my lord, that this order has been passed under the Land Record and Settlement. So even if the concerned authority doesn't quote that I am exercising the power of under the Land Recordment Act, it says that if the source of power is available, The power is available under the act, my lord, which is not dispute, my lord. Then, my lord, quoting or not quoting, referring the law section will not vitiate the proceeding. That once source of power is there. If no power is there, then matter would have been different. Then it would have been different. My lord, the 2002 SCC, my lord, is in respect of the same principle of law. Last page number, my lord, 512.
Yes.
My lord, merely, I will start from merely. Merely because a wrong provision was quoted by the collector for exercising his power while deleting the name of the appellant from the revenue record would not invalidate the order if it is shown that such an order could be passed under other provision of the act, that is so and so and so and so. Here in this case also what happened, my lord? The deputy commissioner quoted wrong section. But deputy commissioner had the power under other act.
Yes.
Then the law says that, no, he might have quoted wrong section, but if it is found that the deputy commissioner has the power, he has rightly exercised the power. Now, my lord, entire reading of the order, my lord, deputy order says, my lord, he is not sitting as their appellate authority under order under section 145, neither he is exercising power under 145. He has specifically said that for revocation of the land allotment. Once you are determining that I am exercising more power, considering the legality and validity of the land allotment order, the moment, my lord, whether his understanding may be 145 or whatever, that will not change the substance. Once he thinks that I am considering the matter legality and validity of the land allotment, automatically land allotment act will come into existence. This is my humble submission.
Do you want to reply? You want to reply?
My lord, he has fairly submitted in his line only. As for direction of the Director of Land Management, Deputy Commissioner has taken appeal matter into his court. So my question, this appeal section itself, is it applicable in my matter? No, because no previous order was passed under this Land Settlement Record Act. And my learned friend has very beautifully described that Deputy Commissioner had passed illegal order by quoting the wrong section. How can he justify? How can my learned friend justify the Deputy Commissioner had made mistake in quoting the section as 145 CRPC, whereas learned Deputy Commissioner himself has replied me in affidavit, affidavit of the Deputy Commissioner may be seen at page 3, para 6, my lords.
Is 83.
Page 3, para 6.
Page 3 of what?
Page the affidavit filed by Deputy Commissioner. Yes, Deputy Commissioner is very much represented by Learned Counsel.
Yes.
Yes.
Para 5.
Para 6, my lord, para 6. Para 6 of Deputy Commissioner, that with regard to the statement made in para 10 of criminal petition, answering respondent begs to state that in pursuance to the direction of Director Land Management Itanagar, both parties were summoned and accordingly proceeded under and accordingly proceeding was conducted under section 145 CRPC. Whereas deputy commissioner can deposit affidavit stating this. Or this is, what called revealing the fact of the order under this paragraph. Now, how can we draw a presumption that deputy commissioner might have quoted the wrong section? And also, Your Lordship, in pursuance to the direction of Director of Land Management. So how a Director of Land Management can order a deputy commissioner to take an appeal unless he is an appellate authority? And also, my lord, how deputy commissioner can take the appeal matter into his court unless he is an appellate authority prescribed under law of Land Settlement Record Act? So unless this is satisfied by my learned friend, and in this case, by the government advocate, so is this order sustainable, permissible? Isn't it arbitrary or whimsical? No. These arbitrary and whimsical order shall not be allowed, my lord, to take field in the to take field in the field of law. This all, madam.
Yeah, Your Lordship. Your Lordship may come to our affidavit, Your Lordship, filed by the government deputy commissioner, respondent number 3, page 3, Your Lordship.
Yes.
Paragraph 5, Your Lordship. Here, what we are saying that there is a, Your Lordship may come, there is a clear provision in the Arunachal Pradesh Land Settlement and Records Act 2000 for appeal, which shall be represented by concerned secretary. This is land management, and your deponent admit that the Director Land Management Government of Arunachal Pradesh Itanagar has forwarded the case white number LM127/2020/114 dated 29/4/2021 and stated that there is no record of personal hearing taken to the appellate by the lower court, which is essence of quasi-judicial process before any appellant. Therefore, you are requested to take up the matter at your level by summoning the party concerned for redressal. And Your Lordship, an extra copy of section 83(1) of APL and SR Act 2000 is annexed an annexer 1, Your Lordship. Here, Your Lordship may come to page 7, Your Lordship. Appeal is there, 83(1), Your Lordship, save as otherwise expressly provided. An appeal shall lie from every original order passed under this act, if such an order is passed by an officer subordinate to the deputy commissioner, Your Lordship.
My lord, only short reply of my lord, learned friend is saying, Deputy Commissioner has made the affidavit saying that I exercise the power under section 140. The question before my lord would be, because it was something like that, I filed the petition under 482. And can the presiding, my lord, court says that, no, though you have filed application under 482, I am passing under 20. It is not possible. His understanding don't matter, but nature of the proceeding will arise from my filing of the application. Then once order rightly or wrongly Deputy Commissioner pass under the Land Record Settlement Act, he has a remedy. Still he has a remedy, not criminal. That's all. I conclude.
The order is reserved.
Much okay.
It's a Your Lordship.
Yes.
Item number 30.
Effective.
Yes. Item number 30.
Yes, Mr. Garum.
Yes, sir.
Lordship, where is the state?
Lords. Before may I please, Lords?
It is a case under section 326.
326, Lordship. Now, Lordship, the fact of the case is that, Lordship.
Now, without going through the injury report, I am
Lordship.
not giving you any favorable orders.
Lordship, now, Lordship may kindly see the FIR, Lordship. Lordship will find it page number 11, Lordship. This FIR was, may Lordship. This FIR has been filed under the banner of Duimok Student Union, Lordship. To the officer in charge, so-and-so, subject FIR, with due regards, the team Duimok Student Union would like to lodge a first information report against one unknown person who has attacked with local dao, one of our central executive member, DSU, Sri so-and-so, son of so-and-so, so-and-so. Incident happened at the Bagate Thinali near Western Bar around 4 a.m. Kindly note the date, Lordship, time, Lordship, 4 a.m. Lordship. Now the Lordship, the applicant,
4 a.m. in the morning.
4 a.m. in the morning, Lordship. Now the complainant and the Lordship, the victim and the accused person, Lordship, they were in the bar, Lordship. All of them, they were in inebriated condition, Lordship. They were drinking alcohol and they were in a drunken state, Lordship. Now what happened, Lordship? When the applicant, he went to the bar, Lordship, at around 9 p.m. at night, Lordship, in order to take a small drinks from the bar. Now what happened? This complainant, they had an argument with the manager in the bar. So in a goodwill of gesture, applicant, he intervened. He said that you have to pay the bill. Otherwise, you are not supposed to leave from the bar. This is how the civilized citizen is supposed to do. In that point, at that relevant point of time, argument took place between the complainant and the accused person. It was resolved because they were in a drunken state. They said that it happens in the bar. We used to drink and we used to make an argument with each other. It happens. After that, once the matter was resolved in the bar, Lordship, the moment the applicant, he went down to, came out from the bar, complainant along with the victim, they were waiting for the applicant in order to assault him physically. And this, Lordship, the local dao which I was carrying in my car, Lordship, it was only to draw out, not to attack anyone, Lordship. It was only to draw out, disperse the crowd because there were 6 or 7 persons were there, Lordship. If I could not take out the dao, local dao, Lordship, I would have been killed by those people, Lordship.
Still then, the case is registered under section 326. So medical report will be required.
Precisely, Lordship, precisely. Now I am saying that, Lordship, this FIR has been lodged on 23rd January 2024, Lordship. 2 months has been passed, Lordship.
How much time it will need? How much time it will need for medical report?
We'll see, my lord. At this stage, I'm not sure. But
He must have been medically examined.
Yes, Lordship, Lordship, because this FIR has been filed long time back, Lordship.
On the date of the production of case diary, my lord, there would be MLC.
Okay.
Subject to the outcome, since the gravity of the offense,
Yes.
subject to the outcome of the MLC, my lord.
Yeah, on 12.
Lordship, in the meantime, Lordship, let me go to the police station. Let me give my statement,
No
Lordship.
interim now. No interim now. You wait till 12. Let the CD come. And more particularly the injury.
Injury report.
Heard Mr. T. Goram, appearing for the petitioner. Heard Mr. J. Seri, Tilana Public Prosecutor for the state of Arunachal Pradesh. Call for the case day along with the medical injury report. Medical report. Medical report. List on 12 March.
My lord.
It is coming from Doimuk Police.
Yes, my lords.
12 March.
Lords, briefly, please.
Obliged.
May I please, ma'am?
Yes.
My lord, this is also a dispute between family members, my lord. So, my lord, on last occasion, on an opportunity was granted by this honorable court also to settle the matter outside the court, but it has not been possible, my lord. My lord,
Both sides are present. It will go for hearing.
my
I'll
lord,
fix a date for hearing. It will require some hearing.
no, my lord, the issue is very small. Only one issue is it, my lord.
Still,
Here,
then it will require some amount of hearing. I'll fix it for hearing. Heard Mr. D. Soki, appearing for the petitioner. Heard Mr. Appearing for the respondent. When do you want it?
My lord, let it be for admission hearing only, my lord. In the last part of this month, my lord.
Last part of this month,
My lord. 26, my lord.
26,
26 March, my lord.
26 March for hearing,
For admission hearing. my
for admission hearing.
lord. All right.
Item number 4.
May I please, Lordship?
Hmm.
Lordship, this is an application under section 482 of CRPC for quashing of,
Joint petition.
yes, joint application filed by the two accused person and the victim of the case.
Who has sworn the affidavit?
Lordship?
Both should have sworn the affidavit.
Yes, Lordship, on the last occasion, this honorable court has given direction for filing affidavit of other two applicants. So on the last date, they have filed
The affidavit.
their affidavit, which is in the record.
Hmm. Okay,
Lordship,
what do you want to say, state? Can it be done
They have entered,
between husband and wife?
yes, now they become, but as a second wife.
Second wife.
Accused has earlier first one wife.
That's
And his accused wife, first wife was alleged of 202 under IPC, concealing the fact of being sexual intercourse with the maid servant.
Oh, अच्छा.
Victim here is a maid servant of the accused, domestic helper.
Oh, अच्छा. Oh, the victim is the domestic help.
Yes, and she is mentally unstable also.
She is the victim.
Yes, victim is a mentally unstable also.
Where is the FIR?
Page 21.
No, who is Fezem Wangsu?
she is the victim of the case.
She filed the affidavit.
Yes, Lordship. She is also filing affidavit jointly. Lordship, now the victim has been married to the accused person. And there is no any objection from the applicant number 2, who is the first wife. In this regard, they have also executed a deed of agreement and affidavit before the executive magistrate. Now both the accused person and the victim, they are living as a husband and wife, Lordship.
Where is the FIR?
FIR.
Page 21. 21.
21. Oh, he married her.
Yes, Lordship, they have already married. Lordship, page number 47, annexure 4 of my application. Here, they have taken a affidavit, joint affidavit before the executive magistrate, Itanagar Capital Complex.
Page number?
Page number 47. Annexure number 4. This is a joint affidavit taken by the accused person, that is applicant number 1 and applicant number 2. Applicant number 3, who is the victim in this case. Now, after the incident, Lordship, both the accused person and the victim has married with each other and they are living happily as husband and wife. And the accused person is a tribal Nisi community.
Hmm.
And in their customary law, Lordship, second marriage is being prevalent. And the same is not being objected by the first wife.
Hmm.
Since, Lordship, the case has been already charge sheeted and trial is yet to be commenced. Lordship, since the matter has been already settled outside the court, so if this case goes for trial before the learned session court also, there is a very remote chance of being convicted. Lordship, maybe
Yes.
dispose.
Yes, since as per record, victim is mentally unstable, and she has been taken to psychiatrist also on many times. So this affidavit may be outcome of misunderstanding or not understanding the. This affidavit may be a lame excuse for escaping from the convictions also. So my humble submission, Your Lordship may not exercise 482 inherent jurisdictions and trial be continued so that a true fact may come out.
Lordship,
Otherwise, accused is admitted that he had some intercourse with the domestic helper who is under his control. Section 376 K and L, under whose control and under one who is mentally or physically unstable. That's all yours.
Okay, petition is allowed.
Obliged.
deep.
Hey, Your Lordship.
Yes.
Your Lordship, this is a bail application filed under section 439 of CRPC. Praying for the release of alleged accused in connection with volume PS case number 07/2023 registered under section 363/376 clause 2 and clause
Where
8.
is the FIR?
FIR is
Who is for a private respondent?
Lordship, as the Lordship, we have served the notice, Lordship, through our PP office and through the registry also, but we have not received, Lordship, their reply, Lordship. Lordship, in the earlier order, Lordship, the first order, we have furnished this, Lordship, notice to the registry. Excuse me. Which have no reply, Lordship. Again, by the order that on the last order, Lordship, we have again served to our WT message, Lordship. On the first occasion, Lordship, we have annexed our petition also with the notice, and second also, on the second occasion, Lordship, we have served WT message. But till now, we did not receive any reply from that side. So Lordship, again, we have permitted Lordship to, this time Lordship to the registry Lordship may do the needful Lordship.
He's from Assam. Punitpur, Assam.
Yes, your, yes, your lordship.
What you will do now?
Lordship, this time Lordship, registry may take the instructions, Lordship. Lordship may serve the notice to the registry, Lordship. Because 2 times we have done our work with through our PP office, but this time registry may do the needful, Lordship.
Hard MS, what is your name?
Talam.
A Talam.
Yes, your lordship.
AP for the petitioner. Hard MS H Lakshmi, the learned additional PP for the state of Assam.
State of A.
Notice upon the private respondent number 2 is yet to be served. The registry is directed to issue a notice to the private respondent number 2. By registered post-it AD.
Your lordship, last opportunity may be given, even in earlier occasion, even in a.
It will take some time. List on when it will come?
21st of March, Lordship, then.
21st of March. List on 21st of March.
Obliged, Lordship.
Number 6. Scan copy of the case record was called for. Is it received?
My lord.
Yes, also received. The trial is going on.
My lord.
How many witnesses are examined in the trial?
4 so far.
Out of?
Out of 10, my lord.
Out of 10, 4 are examined.
Yes, my lord. My lord, let us see FIR first. FIR in page number 11. My lord.
The victim is examined or not?
Victim has been examined. Informant has also been examined. My lord.
You have to wait for some time.
My lord.
Let the trial court examine some more witnesses. Only 4 are examined today.
My lord, till then, trial will conclude. If other witnesses are examined, till then the trial will terminate, my lord. The trial will conclude, my lord. Because day-to-day basis trial was going on. Now the learned presiding officer is out of station on leave for medical treatment, my lord.
The presiding officer. The presiding officer is out of station.
Yes, my lord. On medical ground. And the accused has been under detention since last more than 6 months, my lord.
You have to come after 2 months. Let us see how many witnesses they examine.
My lord, till then trial will be concluded, my lord. Till then trial will be concluded, my lord. Because
only 4 are examined.
Yes,
let them examine 6 or 7 witnesses, then you come.
My lord, the trial is done in such a way that every day 2-3 witnesses have been examined. So if it goes in this way, trial will conclude, my lord, before disposal of this matter.
No, you wait for at least 6 witnesses. Let them examine 6 witnesses, then you come.
My lord, they will not wait after examination of 2 more witnesses, my lord. Because trial was done day-to-day basis, every day.
That is very good. That is very good.
And if, my lord, the accused is not enlarged on bail at this stage, trial will conclude, my lord.
Wow. Have you gone through the evidence? Have you gone through the evidence?
Yes, Your Lordship. Your Lordship, here, victim statement under 164(5).
How much contraband was seized?
220 kg, my lord. But not from the petitioner, my lord. Not from the petitioner.
From whom?
From other persons, my lord.
So why he was arrested?
He was arrested because he was in a vehicle, my lord, along with other person. So that person was the owner of the contraband, my lord. But the problem is this, my lord. My lord, may kindly peruse page 27 for a moment. Thereafter, under the police authorities took the petitioner to at Udalguri, my lord, where dialysis is going on, my lord. On 22nd, from the jail custody to the Udalguri, my lord. That is my kindly peruse, my lord. Yes. Page 27, my lord.
He is taking treatment for dialysis.
My lord, dialysis is going on, my lord. He's not.
Let us see what happens.
My lord, he's not in a position to survive for very long, my lord. Dialysis on a alternative days, my lord, is going on, my lord. And he's in a jail in now Bomdila, my lord, where dialysis facility is not available, my lord. He cannot eat properly. He cannot drink properly, my lord.
Where he is now detained?
He's in Bomdila, my lord.
Bomdila.
Bomdila. In a very small cell, my lord. There is no jail facility also is there, my lord. So I'm just praying for an interim bail, my lord, because if your lordship don't allow me bail at this point of time, he will not survive, my lord.
He will be. I think he should be shifted to some better place.
That
He can be shifted to better place.
That is there, but
To Itanagar?
as per the doctor instruction, within 2 months, my lord, one kidney has to be transplanted, my lord, and his own father is ready for the same, my lord. So if your lordship allows us, at least we can try to transplant the kidney, my lord. That is very important, my lord.
You wait for some time then.
And in between, my lord, if
I'll have to go to the case day.
My lord.
Hard, Mr.
S. Chaudhary. My lord,
S. Chaudhary.
another thing is that medical report may be called for. That is much necessary. my lord.
Preparing for the petitioner. Hard, Mr. G. Talo.
G. Tado.
G. Tado. They learned additional PP for the state of Assam. Call for the case day. He is in which jail? Bomdila jail.
Bomdila. There is no jail cell like my lord.
Huh?
Jail, you can lordship, you can say jail.
The jail authority where the petitioner is now detained shall forward to this court a report regarding his health condition. When the day will come? Give a short date.
My lord, may it be possible to give on Monday, my lord?
Monday it may not come. Which is the police station?
That Bhalapur police station.
Was coming.
Hmm?
Bhalapur was coming.
Bhalapur.
Not very far, my lord.
14.
It will not be possible for me, my lord. If possible, Monday it will be very.
Monday not possible. Monday
Tuesday, my lord.
Tuesday, what is the date?
12, my lord.
It will come or not?
It may not be. Because Bhalapur is a distant place from here. Was coming.
A distant place.
Today is 5 and 14 is only 9 days.
Only 9 days. Okay, on 14 then.
I will not be able to do that.
You come
I came from Guwahati, my lord.
You come from Guwahati?
My lord.
Then you take 12, it may not come.
13, my lord.
13, okay, 1 day less than what the
What
state
is
is
it, my lord?
on 13. 13, let us see whether it comes or not.
My lord. Lordship, more than the CD, the medical report is essential, my lord.
Okay.
Because,
Let us see whether it comes or not.
Because so far the CD is concerned, section 37 will be there, my lord, to infringe him, my lord. That is there. But I'm only on the basis of the medical ground, my lord. Nothing. I'm not going to the merit of the case, my lord.
If your lordship permits me, I would like to place some judgments, if your lordship allow me.
On the next date.
My lord, on 13th, my lord.
Obliged. Seven here, as per office note, ID card not yet written.
Not yet received.
May I, my lord? My lord, I would like to withdraw KW and Arriba from Bacalat now.
You want to withdraw this?
Yes, no, name of the advocate council. KW and Arriba from.
You want to withdraw it?
Withdraw my name, Your
Oh,
Honor.
you want to withdraw your name?
Yes, Your Honor.
What is your name?
Your Honor, the main council is from Guwahati. He's Varun Daka, Your Honor. Varun Daka. It should be, yes.
Your name is?
Arriba, Your Honor.
Arriba.
Yes, Your Honor.
The learned counsel, Mr. Arriba, appearing for the petitioner, submits that he intends to withdraw from this case. I have heard Mr. Arriba. The prayer, Mr. Arriba, is allowed. The name of Mr. Arriba shall not be shown in the cause
And
list.
KW, Your Honor.
Huh?
Arriba and KW.
K. Riba and K. Dabi
Yes, Your Honor.
shall not be shown in the cause list as the counsel is representing the petitioner. Office is directed to issue a notice to the petitioner. List after 4 weeks.
Much obliged.
Obliged.
Sorry to interrupt you, lord. Can be on 18th, my lord. It may not be.
18.
My lord.
Make it 18.
Of the laws. Item number 8.
Yes.
And I'm appearing on behalf of Mr. S.K. Dury.
Hmm.
And in this case, on the last date, which was on 20th November 2023, steps were taken on respondent number 2. However, I believe the service is still awaited.
Oh, it's respondent number 2.
Respondent number
Notice
2.
not yet served. Hard MS,
T.Y. Buttigieg.
appearing for the petitioner. Hard MS H. Lakshmi D. Learned, additional PP for the state of Assam. You take fresh steps for service of notice.
Okay.
Oh, it's on the last date. When did you take steps?
I'm not aware with regard to the date, Your Honor, because the councils are from Guwahati.
Await for the service report in respect of respondent number 2. List after 4 weeks.
Highly aware. Okay.
Item number 10 and
May your lordship, I'll be filing Wakalat number on behalf of respondent 16 and 17.
16 and 17.
Yes, your lordship.
$294. Who is for the other respondents?
My lord, I'm on behalf of respondent number 2, my lord.
Huh?
Respondent number 2, my lord. My lord, I am still not get the copy of the IN.
You are for respondent number 2.
Yes, respondent number 2. Maybe.
And you are for?
16, your lordship, 16 and 17.
16 and 17.
My lord, I am for respondent number 3 and 6. 3 and 6. This morning I filed a Wakalatnama.
Okay, 3 and 6. Heard Mr. Opada appearing for the petitioner?
Statement.
Applicant state.
Yes.
Heard Mr. What is your name?
Odugon.
Appearing for the respondent number 2.
2.
Heard Mr.
X Yati, 3 and 6.
Appearing for respondents 3 and 6. Heard MS.
8 along.
Appearing for respondents
16 and 17.
16 and
17.
16 and 17. The learned counsels appearing for the respondents submit that they have not yet received the copy of the application. Therefore, the applicant is directed to provide copy of applications to the said respondents. Least after 3 weeks.
My lord.
Yeah, my lord, they filed an IA, my lord.
Hmm.
And I need further instructions from the client, my lord, so that I can file the objection, my lord.
Okay. So who filed this IA?
The IA, in IA 12, my lord, item number 12, my lord.
Item number
12.
12.
Oh, no, sorry, my lord.
Hmm.
Item number 13, my lord.
13.
Yes, my lord.
No, in item number 12, who filed this IA? IA number 100.
In fact, my lord, there is an order from this honorable court, my lord, asking me to pay the degree amount, my lord. Now they have filed an IA, and which has been straight, my lord.
Hmm.
And on the last occasion, my lord, I was supposed to file an objection, if any, my lord.
Is it a money suit?
Yes, my lord. Yes.
Yeah, who is the appellant here?
Appellant, my lord, the State Bank, and there are two other appellants, my lord.
I'm in item number 13, representing state.
No, who is in item number 12?
I think today nobody has appeared, ma'am.
Oh, it's-
Mr.
item
S.
number
Taye was
12?
here, ma'am.
In item number 12, IA number 100,
My lord.
none appears for the applicant. Heard Mr. Upada appearing for the opposite party.
Hmm.
Since none appears for the applicant on call, the matter is adjourned today. Least after 3 weeks.
My lord.
Then item number 13, where is it?
Item number 13, Lordship, I'm
13 is
representing.
the State Bank is here,
13.
ma'am.
Analogous matter, Lordship. Our case is
I-
already admitted.
Your appeal is admitted.
Yes.
Yes.
And where is the IA number 58? It is not listed. It is listed today. I
So, नहीं लाया, नहीं लाया.
number 58. Pada is for a respondent here.
Yes,
Respondent
ma'am.
number 1.
Yes, my lord.
You want time to take instructions.
My lord.
Who is the applicant here?
In
Who filed
item
this?
number 13, State Bank of India, is Pasighat branch is the one that we have.
Acha, you are the applicant.
Yes.
Hard MS. What is your name?
S Nag.
Huh?
S Nag.
S Nag, appearing for the applicant. Hard Mr. Upada, appearing for the
I will
opposite
respond,
party.
my lord.
Number 1.
Yes, ma'am.
Mr. Pada submits that he needs some time to take instructions from his client. The prayer is allowed, least after 3 weeks, along with item number 12.
Deeply obliged.
Okay. At 2 p.m.
State and lower LCR was called for, Your Lordship. In this case, Your Lordship, both the parties, the complainant and the alleged accused person, they reached and amicably settled the matter. And during the commission of this alleged offense, all the petitioners were minor.
Yes. Where is the FIR?
FIR is at Your Lordship. Page number. Page number 16, Your Lordship. If Your Lordship permit, I may read the FIR, Your Lordship. To the officer in charge, Itanagar Police Station, FIR against local unknown 5 persons. Sir, with due respect and humble, I beg to say that I, Sri Kabir Ahmed, working at fabrication welder at Niti Bihar, when we close our shop at 9:30 p.m. And after then we came at home and we start our cooking dinner at that time. 5 local persons entered at home and asked me give matchbox. When I ignored them, they all are start to beating all of us and take away our 3 mobile phone and sum of rupees 40,000 amount of money. I enclose here, here our mobile case memo. This was the FIR, Your Lordship. FIR was lost on dated 10/12/2017, Your Lordship. And on 29/8/2023, there was a settlement agreement whereby the informant had forgive those alleged accused petitioners. And during commission of the alleged offense, all these accused petitioners were minor.
Yes. Gaurav? This is a joint petition.
Yes. They have amicable settled the matter.
Okay, it will be done.
Yeah,
It is cost.
Like-
May I, Your Honor? And I'm appearing on behalf of Mr. Mukherjee, standing counsel for the Guwahati High Court Itanagar Permanent Bench.
Was a VC. Today not.
Lordship, I am appearing for, yes, my lord. Lordship, I am appearing
Yes.
for the petitioner, my lord.
But in this
My
case,
lord,
we're supposed to
affidavit was
file our
supposed to file.
affidavit.
Affidavit of opposition not yet filed.
It's not yet been filed because we've sent the affidavit for vetting to the Guwahati High Court.
My lord,
registrar.
You file it next week.
My lord, may kindly have a look at the orders, my lord. Kindly look their conduct, my lord. Because,
Okay, I will give them a last chance to file.
my lord, already on 29th of January, last chance opportunity was given. On 29th
No
of
further opportunity shall be given.
my lord,
Heard, Mr.
BM Decca, my lord.
BM Decca appearing for the petitioner. Heard, MS
T.Y. Bhutia on behalf of Mr. Mukherjee,
appearing for the
standing counsel, Guwahati High Court.
standing counsel. The so-and-so standing counsel, Guwahati High Court.
Itanagar Permanent Bench.
MS so-and-so. Wait for some more time to file the affidavit in opposition. Mr. Decca has objected to it on the ground that the respondent has already taken many adjournments on that ground. I have considered the submissions made by the learned counsels on both sides. One last opportunity is given to the respondent to file the affidavit in opposition. No further chance shall be given to the respondents to file affidavits. List again after 3 weeks.
Deeply obliged.
My lord, one more submission, my lord. My lord, already a recruitment drive has been carried on by the respondent in the same post, my lord, because already one post is vacant wherever we are seeking transfer, my lord. And if that on 8th of March, my lord, it is going to be filled up, my lord. If it is filled up, then we will be surely deprived, my lord. That is my anxiety, my lord.
Okay, you wait for 3 weeks.
My lord,
After 2 weeks, make it 2 weeks.
a date may be fixed, my lord.
After 2 weeks, one date. March. 26 March.
26 March, my lord.
Yes.
Okay.
Deeply obliged.
Item number 17 and 18.
Yeah, Your Lordship. Your Lordship, this is an application under 167. And on the last hearing, Your Lordship, the learned PP was to take instruction from the lower court whether whether it is charge sheeted or not.
Charge sheet filed or not? What is the maximum period of detention?
60 days. Intermediate range.
Huh?
Intermediate range, 60 days.
60 days.
Yes.
Charge sheet filed or not?
Not yet filed.
Charge sheet not yet filed. How many days he is in custody?
He was arrested on 29th December 2023. Yes,
60 days already complete.
complete.
As of today, it is 66 days, Your Lordship. And at the time of filing, it was 62 days.
Intermediate amount, no?
Yes, Your Lordship.
Not commercial quantity.
Not commercial.
Commerce.
It is 60 days.
Yes, 60 days. as per section.
What is the section? 21B.
21B.
Heard the learned counsel, Mr.
J Typodia.
J. Tapodia,
Yes.
appearing for a petitioner. Heard Mr. G. Tado. The learned additional preview for a state of Assam. This is an application under section 439 of the CRPC. In respect of 0 PS case number 42 of 2023 under section 21 within bracket small b of the NDPS Act. The bail application has been filed on the ground that the petitioner has already completed more than 60 days in judicial custody. Mr. Tadu has submitted that this offense prescribes maximum period of detention of 60 days under section 167 of the Criminal Procedure Code. Today, the petitioner has completed 66 days in judicial custody and no charge sheet has been filed. Therefore, the petitioner is allowed to go on default bail. He shall be released on bail of rupees 25,000 with a surety of like amount to the satisfaction of the learned special judge. 0. Isn't it?
Yes, 0.
Special judge 0. The bail application is disposal.
Your Lordship, Your Lordship, what is the amount? Your Lordship? Amount?
25,000.
Your Lordship, may reconsider the amount, Your Lordship.
20,000.
Oh, yes. Much obliged.
CD may be written, Your Lordship.
CD shall be returned.
Obliged.
Notice served or not?
My lord, in a WPC, notice has not been served, but we have inquired with our clerk that he has taken steps, but probably he has taken steps wrongly in the FAO. So notice has been not served in WPC. But I think my learned friend is more aggrieved by the first appeal, the FAO that is pending before this honorable court. And if we are ready for the hearing, my lord.
Today it is for orders only.
My lord, the writ petition is concerned, my lord, it has basically not very much, my lord, relevance for the consideration of FAO, my lord. My lord, this in the FAO, my lord.
Rejoinder affidavit, who was to file? Rejoinder affidavit?
Actually, my lord, in this WPC, my lord,
No, in this FAO?
FAO, my lord, we are supposed to file, but we're not filing it.
You are not going to file?
We're not going to file it.
Then it is for orders. It will go for admission hearing then.
Yes, my lord. And my lord, there is urgency, my lord. There is even mandate under the CPC, my lord, because, my lord, the appellant has obtained ad interim ex parte injunction. And my lord, that's why, my lord, now it is supposed to be, my lord, heard within 1 minute, my lord, but almost more than 4 months, my lord, now.
Okay, yes.
But that is subject to, my lord, if the...
And my lord, I think 3 days back, even the apex court has passed one judgment saying, my lord, when such ad interim order is passed, my lord, and the early efforts should be made to dispose, because, my lord, I have not been heard. Without hearing me, my lord, this injunction has been issued.
Okay, all right. Heard Mr.
NBP Singh.
NBP Singh appearing for a petitioner. Heard Mr. Ratan appearing for the
R. Sonar, my lord.
R. Sonar.
My lord.
I always confuse.
My lord.
Heard Mr. R. Sonar appearing for the respondent, sole respondent. Mr. Typodia submits that he is not going to file a rejoinder affidavit in reply to the affidavit in the position filed by the respondent. Therefore, leaves the matter again on.
My lord.
What is the date today?
Today is
6.
5, my lord.
Today is 5. 18.
18.
Monday.
Monday, my lord. Yes, my lord.
List on 18.
My lord,
18
may-
March
my lord,
for
may-
admission hearing.
my lord, may I pray, my lord, that my lord, the WPC may be segregated from this
Yes,
FAO, my lord. Otherwise, my lord,
WPC may be segregated.
may be segregated.
You write an order in the WPC. Heard Mr. NBP Singh. WPC you filed.
Yes, my lord.
NBP Singh appearing for the petitioner. Heard Mr. R. Sonar.
My lord, I have an instruction to appear, although they have not taken service, this, serve the notice, my lord, for respondent number 3, my lord. On instruction, my lord.
Okay. Heard Mr. R. Sonar appearing for respondent number 3. But his name is same as yours name, Typodia.
Yes, my lord. Actually, my lord, WPC, my mother, and the FAO, my lord, the daughter, my lord.
Oh, sir.
They are also, my lord, son only.
Oh,
It is among the family, my lord.
within the family.
Yes, my lord.
But notice has to go.
Yes, my lord.
My lord.
The petitioner shall take steps for service of notice upon the remaining respondents by registered posted AD. Least after 4 weeks.
My lord, and FAO, my lord,
My
that.
lord, FAO, can it be on 19th, my lord? We have
Okay,
some
on-
difficulty
on
on it.
FAO 19
19.
For admission hearing.
for admission hearing.
Of like,
Much-
Please, please. Please, please.